best for them. Now you say, no, the government also did not know what it was doing. Court also did not know what it was doing. Nobody knew what it was doing. Start de novo.
What will be the quantum of compensation is an entirely different question. That question is entirely different. So therefore, on the question of jurisdiction, there is no going back.
There is no trial, there is no determination. There is nothing.
Therefore, they wanted to avoid.
Two parties.
Union of India wanted to avoid a trial. UCP wanted to avoid a trial.
Two parties decide to avoid a trial, settle on a figure. They may have their own business decisions to settle. You had your own reasons that the time periods and the manner of fixation of liability would take it very long. You agreed to settle. Without any of the substratum of a suit trial, when no finding has taken place, you want to fast additional liability. How do you do it? Under what principle? Earthly principle of law do we do it?
In large number of such mass transactions, settlements do take place.
Yes.
That's it. Because you have a certain give and take. But then who gains out of it?
Don't know.
For commercial reasons, for business proposals, you say I'm going for a settlement, then tomorrow it is found, and I'm trying to find, tomorrow in a case it is found that you settle on a very poor scale. You settle for a very poor scale. That's why the doctrine of tracing restitution, you avoided a certain expenditure, escaping expenditure. That could always be taken. That could be avoided it. You know that in future you will have a certain liability. You want to settle it quickly. Union of India had to that point of time said, well, yes, I want to even succor to the victims.
They weigh the possibility that if an adverse view would come, what are the consequences which may flow? You weighed that if you're not able to get the right kind of judgment, and even if you get the right kind of judgment, how to execute it, how will it operate? These are calls taken, and this judgment deals with it and says, look, justifies in view of all this hullabaloo at that time which was there, because there were a section of society feeling, no, this is not fair to us. Therefore, such a long judgment explaining what is sought to be raised, why people sometimes are not understanding what is best for them. The government did what is best for them, the court did best for them. Now you say, no, the government also did not know what it was doing. Court also did not know what it was doing. Nobody knew what it was doing. Start de novo.
Let's kindly turn to paragraph 198.
Yes.
I would have said yes to yes. The observation is absolutely valid because in a different context they would have been unquestionable. But in a context like this, I think there's a need to go beyond the customary principles of tort law and negligence, economic laws, the gain laws, etc. will all be kept aside. So paragraph 198, page 157. After a careful thought, it appears to us, while it may not be wise or proper to deprive the victims of the benefit of the settlement, it is our necessity to ensure that in the perhaps unlikely event of the settlement fund being found inadequate to meet the compensation determined in respect of all the present claimants. The court was still talking about the present claimants.
Yes.
Those persons who may have their claim determined after the fund is exhausted are not left to fend for themselves.
Yes.
Such a contingency may not arise having regard to the settlement of funds. These are all a certain set of assumptions. If it should arise, the reasonable way to protect the interests of the victims is to hold that the Union of India, the welfare state circumstances also should not be found wanting to make good the deficiency of any. We hold and declare accordingly. Is this principle a valid principle? So in the threat petition, we say this principle needs to be revisited. So the court left this open. There is the possibility for the present claims. And then in 1992, the number of claims were registered were not even complete. By 1996-97.
The judgment goes further. The judgment takes a note that medical evaluation is still incomplete. And if some claims arise out of that completed medical evaluation, what is to be done? That is also mentioned in paragraph 206 and 207. You may go to that later on. But there is the answer to that. That if more claims will arise, who those claims are to be dealt with?
Who should bear the liability?
Right.
And who should bear the liability?
There is a complete answer to that.
First is answer is Union of India will bear the liability.
Yes.
206 and 207.
The question of why this is what you agreed to.
No, the question therefore is if there is a need to look at it, how did the court put it? Court put it well. Yes, parents patria. There is a Union of India will step in and bridge the gap, and because
So Union India came forward as parents patria to file this suit.
that is for a different purpose.
Wait. You come to your plaint and see on page 216II that the total claims made at that time were already registered at number 5,31,770. There were 2,660 deaths. And you have given the figures also that this would be the approximate
That is
claim.
true.
Correct.
That's true.
And then you see the relief claim. And then ultimately you entered into a settlement.
True.
In February 1989.
February 1989, the process of understanding the magnitude of the tragedy and then
No,
enumerating
the claims of 5 lakhs were already registered at that time when this was filed.
they were only part of the persons who were affected. We had 10 lakhs people who
Just
came
one
to be the. So therefore, about 5 theoretically is after a factual enumeration.
After
By
factual
the-
enumeration,
by-
you are
by-
talking about 10 lakhs, while actually you found, or the concerned authorities found 5 lakh claims. were there.
Correct. That determination is as to a process of
Yes.
law,
And
through a
therefore,
statutory process.
What would happen if more medical issues arise? As my brother points out, para 206 talks about a scheme for it.
There is a scheme under the Act. Under the Act, if the court takes cognizance of the scheme, and under the scheme, if the welfare commissioner has dealt with all the applications with a final date for registration, and in 2004 you find these are the number. So therefore, either you completely give a go by to the statutory scheme or the Act, the settlement is final because Union of India could not have done better at that point of time. Close it. But if the statutory scheme has been endorsed by this court, if the Act has been set aside, it would have a different scene altogether. The Act has been set on Constitution, the scheme was received as imprimatur by the court, and under the scheme, proceedings have taken place. So does the proceeding do not have a.
Paragraph 206, 207, and 208 take care of two categories of claimants. One, where those were already under treatment, and secondly,
Yeah.
those who were born subsequently who were affected by this. Both the categories are taken care of by paragraph 206, 207, 208. Both the classes of cases are dealt with.
They are, in great respect, in substitution of the liability of UCC
Yes.
and in substitution of the liability of UCC for whatever reasons the court might have thought at that point of time.
Whatever reason they thought and you thought also.
No, the court, with the great respect, the court thought that.
Court on the arguments that tried to structure it further. This may arise, so let's do this. This may arise. Otherwise, once the settlement is done, it's done. Chapter is closed.
There are therefore
In your wisdom or lack of it, you settled it. And it is not lack of wisdom. You knew very well that the problems which have been sketched out in these judgments. Why you did it? The court gave its imprimatur because there was a thought process involved behind it. The thought process was valid. Money would not have seen the light of the day. You knew it.
No,
For 2 decades, the money would not have seen the light of the day.
I did not.
Today, you want to fasten it, knowing fully well that for any court to be favorably considered, it will never see the light of the day. The money.
No, I did not present any canvas, any argument or a proposition that the settlement should not have been arrived at that point of time at all. The Union of India probably did the best at that point.
Right thing.
And then so many things happened. Canvassing against it or in favor of settlement.
So just see
So-
paragraph 205 onwards as a complete scheme,
Yeah,
which is part of the judgment.
This,
We don't know-
that
we don't know
comes
the
to that question. No, but I thought you lost
Was this scheme implemented ever? Was made or implemented?
Just read that.
I'll read that. I'll read that.
Here.
My instructions are it has not been implemented. Of course, it would structure. I instructions.
No, it's a matter which Union of India has to bear a responsibility, if at all. That are not a different question. But as far as
Did you do
UCC
it?
is concerned,
Did you do it?
no, whether do it, that's a different issue. But UCC
Maybe a
cannot be
different
held
issue.
to
Did
say-
you do it?
Okay,
My
that's
question is, did you do it? Yes or no?
I'll address that question, but UCC
Not a
cannot
very
be held
simple
to say-
answer either, yes or no.
Mr. Parekh is saying you have not done it. That's what he's saying.
I'll just give you. No, but my sufficient response to it, UCC cannot be heard to say, oh, here you were a possibility where all these additional claims can be settled. The court has looked at it, therefore I'm a free bird. They certainly cannot say that. And
Should not be.
Mr. 3, the court proceeds to dispose of all those contentions and answer to
Yes.
it reiterates at page 163 bottom
No, we are on
what
this,
is
that
stated in paragraph 98.
the policy should be taken for not less than 1 lakh people. Then how the claims will be honored, it is all mentioned in paragraph 208, 209. The scheme which is devised so that any claim arising in future is paid through insurance. That's paragraph 207,
209, 2010, yes.
Also, paragraph
Detailed
21.
set of observations.
Paragraph 221.
as a complete scheme which deals with not less than 1 lakh people whose claim may arise in future.
Page
So whether your curative petition says,
paragraph 209.
correct, whether curative petition says anything about implementation of these elections.
It doesn't.
Doesn't say that.
Paragraph 209, the premier for the insurance shall be paid to the Union of India out of the settlement fund. Not an independent fund to be created.
But out of the settlement fund, again, I'm
So therefore, how much do I put my hands into the settlement fund? And then,
How much?
therefore,
That
if
settlement
I have to,
is still
No.
with what Mr. Salve points out, still 50 crores of the settlement fund.
that 50 crores, and that will answer that question. The 50 crores, there were 435 claimants whose case were decided for a number of reasons. The cases are still pending. 50 crores will be discharged to those who come forward take this money.
So where
There's nothing which remains undisbursed.
it is remaining as on today.
No, 435 applicants.
39
So there
days
is
left, it is 30
there are
days
no
left,
fees
still
pending.
undisbursed.
No. 50
What are we
crores
talking
is
about?
not what we are probably talking about.
No,
We're
but
talking
so we take it that
Yeah.
this entire scheme, though at that time money was available
Yeah.
out of the settlement funds, this scheme was not implemented.
Right, because this the adequacy of the amount itself got exhausted. You got it exhausted by
In,
paying.
in 1991, the
No, no.
amount got exhausted.
Not
This
in
is 1991 direction
Not
to
in
take a policy for not less than 1 lakh possible
You
claimants.
got to look at. I understand that, but
Right.
it was not done. But the question is, I'm trying to look at it from a very broader perspective.
No, but is
So
it,
in 1990,
no, we are asking a question.
Your Lordship, I just come back to
No,
the
I
correct.
ask you very,
I'll come back.
now we understand your concern for the claimants. People are raising voice. You are absolutely right. But here is the case in 1991, court directs you to do something, which today we are on 2023. Till filing of curative petition, do anything for 19 years. And now today we find a scenario that this would have helped at least lakh of people, if not more. And that part is not implemented by Union of India.
I'll come back with a
Explanation for that.
precise set of.
It would have helped more than 1 lakh people.
I will come back.
Because the paragraph 206 says for not less than 1 lakh claimants, policy should be taken. That's what the direction is.
I'll come back to that.
Saying you can't take away my basic right under the rule of law to bring an action. Your Lordships upheld it, saying the government of India successfully argued, parents patria, we are entitled to take over and represent the people. Now, if you say parents patria wrongly applied, then that act is a question mark, then your suit goes for locals.
I'm not canvassing proposition at all. The parent act, I say the power coupled with the duty. If there is injustice, I must undo the injustice. I'm not saying I'm relieving myself of the parents' patria responsibility. In fact, by filing the curative petition, I'm discharging that responsibility. Your Lordship may pick up volume 1 of a compilation of judgments which are placed in the court. Let me straightaway take Your Lordship to the Buddha.
No, this will be either distribute. So at that time, you could have easily done that. You don't refer to the funds now available and say with reference to 435 cases, those may be distributed there. You see, what's being highlighted is, we appreciate your concern. We are not, but one is the issue with regard to the limited jurisdiction we exercising, which you are saying we should extend. But this question has been addressed squarely and completely in the review application. Because by that time, substantially 370,000 odd claims had already been verified and
Right.
claims had been granted.
Right.
So they were aware that further claims were arising. It's not that they were not aware, they were also aware of the facts and figures. They were also aware of the facts and figures at that time. So, and the formula which you have devised, the 3-step formula, which is at page 3 of your appendix A, is a little debatable. Let me put it very clearly, it's very, very debatable. The figures and data can be changed and understood in different ways. And the difficulty is you should have done that. The difficulty is you should have done that. There was some direction given and that cannot be ignored. That could have been easily done.
On a balance of
And they are finding that at that time, as per exchange rate, 1,200 crores were available. That's also a finding. This amount could have been utilized part of it.
All that is, I have 2 scales on my hand. Put all in one scale. The other scale is this whole journey of doing complete justice to the claimants is final or not is a question which I'm trying to ask repeatedly. For that, what are the things I must put in the other scale? The only thing that I can put in the other scale is that repeatedly again, the figures which are now merged out. And we just take a note of in paragraph 37 of the first order. So which scale will go down?